Okay, it's great to be here and fantastic audience. So I have the difficult job of talking about a subject that you all probably know as well, if not better than I know, and that's the admissibility standards that accompany a lot of these questions. So it may be that we know with some degree of confidence that the tumor that Mr. Oft suffered from caused his or was deeply associated with his behavior, and some of the other issues that Adrian raised are really proof problems. And so we may be disinclined to go down a certain pathway, not because we wouldn't be inclined to do it if we had sufficient proof, we simply don't have sufficient proof, and the proponent who is making that argument has the burden, and if you don't meet that burden, you're out of it. So my job, as I see it, is to, first of all, just to quickly go through the admissibility standards, in particular the federal admissibility standards in Daubert, and then I want to get to the group to individual problem that has come up several times today. So this is really just a refresher. You all are experts on Daubert. So of course the first decision, the Daubert trilogy, was Daubert itself in 1993. The U.S. Supreme Court held that trial court judges are gatekeepers, and as gatekeepers, they have the responsibility to determine the relevance of the proffered expert testimony, and under Rule 104A, they have to find by a preponderance of the evidence that the methods and principles underlying the proffered expert opinion is valid and reliable. I prefer the term scientifically valid over evidentiary reliability. The court kind of mixed up that reliability-validity distinction. And it turns out to be, I think, important for some of the things that Oliver was talking about as well. One of the advantages, so reliability is consistency in science, validity is more like accuracy. And so it may be that neurobiological tests will end up being just as valid as the behavioral tests that they're actually being validated against in terms of accuracy, but in the long term might be more reliable, that they'll be more consistent. So one of the advantages of having neuroscience would be really to tighten up the reliability and the consistency and may not affect the validity all that much, but that would still make them quite useful. Of course, again, so the holding of Daubert is that trial courts have to find that the underlying methods and principles are valid, and the court suggested that there were 4 factors that courts might employ, and there are others. Testability and the results of testing, peer review and publication, error rate, and general acceptance. So that's the opening gambit. Part 2, of course, is General Electric Company versus Joyner. The court in Joyner, interestingly, it was Chief Justice Rehnquist who wrote the opinion in Joyner. You may remember that he concurred and dissented in Daubert, worrying about whether judges should be amateur scientists, and then by the time you get to Joyner, he's writing the majority opinion, very much the amateur scientist, and I mean that in a positive sense. The main question in Joyner was whether appellate courts are also gatekeepers in the process of admissibility of scientific evidence, and the Supreme Court said no, that the standard on appeal is the abuse of discretion standard. The Supreme Court took the view that scientific evidence was much like other kinds of evidence, and therefore they're going to defer to the trial court. My apologies to the district court judges in the audience, but I think that the Supreme Court didn't quite get it exactly right on that, and I'll come back to that in a little bit. In theory, this is a standard that's highly deferential to trial court discretion. In practice, it really remains to be seen. There are lots of examples where appellate courts are fairly active. Just recently in the First Circuit, the Acuity case, the First Circuit was very active in reversing a district court decision in a civil case. However, the question of whether the trial court properly applied Daubert is a de novo question. So the question of whether the rules were applied correctly is one that is applied without deference. The third part of the Daubert trilogy, of course, is Kumho-Tyre versus Carmichael, which is 1999. The court again reiterated the gatekeeping responsibilities of trial court judges. The issue in this case was whether the Daubert standard applied only to scientific evidence. What had happened after 1993, as many of you know, is that a lot of specialties and technicians that appeared in court started running from the scientific label. So forensic scientists, clinical psychiatrists, clinical medical doctors started saying, well, we're not really scientists, and therefore we shouldn't be held to the tough gatekeeping standards of Daubert, and that basically Rule 702 of the Federal Rules of Evidence did not apply to non-scientific expert testimony. Justice Breyer wrote the decision, and he held that Rule 702 does not make a bright line distinction between scientific and non-scientific expert testimony, and that the gatekeeping requirement, remember the holding of Daubert is that judges have to be convinced by a preponderance of the evidence that the basis for the proffered expert opinion is valid and reliable, and that's as true for real estate appraisers, as accountants, as auto mechanics, as neuroscientists, as nuclear physicists. The court went on to hold, once again, being extremely deferential to district courts, that not only is the admissibility decision to be deferred to, but the factors that the district court uses to evaluate all of this myriad of different kinds of expert testimony, that too appellate courts owe deference to. And I'm not sure that that's scientifically justifiable, and we can talk about all of these things afterwards during the discussion period. The court did, however, say that some set of criteria must be used, and district courts should be expected, and appellate courts have held district courts to this requirement, that district courts, when they do the admissibility decision, whether they admit or they exclude, they have to give reasons. They have to say what were the criteria that they used to assess it. And then Justice Scalia wrote in a concurring opinion in Kumho-Tyre that if the Daubert factors should apply and the district court fails to use the Daubert factors, that itself might be an abuse of discretion. So, of course, the three cases of the Daubert trilogy are 93, 97, 99. In 2000, and this is actually going to be the restyled rules, the federal rules were amended to reflect the Daubert trilogy. And so the current Rule 702 provides that a witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of opinion or otherwise if the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or determine a fact in issue, basically the relevance inquiry. The testimony is based on sufficient facts or data. The testimony is a product of reliable principles and methods, and we're going to go through these. The expert has reliably applied the principles and methods to the facts of the case. D is actually one that is not cited as often as you think it might be, given sort of perspectives on science. And actually, David Bernstein just recently wrote an article where he surveyed different opinions, and he found that district courts in particular, but appellate courts as well, cite Daubert to exclusion of citing Rule 702. And he makes the point that Rule 702, which was amended in 2000, is the rule, and it's the rule that now embodies the Daubert trilogy. So if you don't want to be criticized by the David Bernsteins of the world, then we ought to be looking at Rule 702 itself. One quick statement just about the Daubert trilogy and Rule 702. There's a great deal of debate about whether Daubert was intended to up the threshold, to make it more rigorous and difficult to get expert testimony in. I don't think it's that close to call. I think that the Supreme Court meant, and this is my own theory, but I think it's borne out by the facts, that the Supreme Court intended the Daubert trilogy to be a case management group of cases, and Rule 702 reflects that. That is just like in the Celotex, it's in the tradition of the managerial judging. And if you look at the three cases of the Daubert trilogy, in all three cases, the expert testimony was excluded. In all three cases, the proponent of the expert testimony lost on summary judgment. And so if there's any doubt that at least the Supreme Court's own understanding of the Daubert trilogy, it seems to be that they're moving up the analysis, and we have the case involving class actions before the court now, which will actually move it up even further, at least for certifying class actions. So I think that very much Daubert is this case management device. One other case that isn't generally known that I think also supports this is a case called Wisegram versus Marley. I don't think there's anybody here from the Eighth Circuit, but the Weisbrand versus Marley was an Eighth Circuit case. In that case, the trial court had admitted arson experts in a civil case involving an insurance company, and the plaintiff won and gotten damages at trial. The Eighth Circuit found that the trial court had abused its discretion in admitting the three arson experts, and found that if you exclude the arson experts as a matter of law, the plaintiff now did not have sufficient proof to go forward, and the Eighth Circuit directed a verdict for the defendant. And so the case went up to the Supreme Court on the question of whether an appellate court has the power to direct a verdict, or basically direct a district court to direct a verdict for the defendant, or should the plaintiff have another bite at the apple? After all, the plaintiff got in that case, his expert testimony in a trial, and Justice Ginsburg wrote the opinion. So again, you get this, it's almost a unanimous court. I mean, Justice Stevens was really dissenting from the Daubert trilogy, and Justice Ginsburg wrote the opinion saying that attorneys should understand today, post-Daubert, that it is a very difficult standard to meet, and they should come forward with their best evidence initially, and they affirmed the Eighth Circuit. And so they basically said the Eighth Circuit was correct in excluding it. So you have 4 cases where the result was summary judgment on the basis of this sort of managerial judging that's going on. Now, that's happening on the civil side. Whether that's exactly happening on the criminal side, there's a great deal of debate, and we can talk about that too. There seems to be at least some observations among some scholars that judges are a little bit more rigorous with Daubert on the civil side than they have been on the criminal side, and there may be lots of different reasons for that. So the other rule, of course, is Rule 403. I won't read it. It's basically the evidence presents substantially unfair prejudice. Rule 403 allows you to kick out evidence even if it were otherwise admissible under Rule 702. I want to come back. Rule 403 is important in the neuroscience context for the fear that neuroscience imaging might overwhelm the trier of fact. So I'll come back to that. So applying Rule 702 in the Daubert trilogy and Rule 403 to neuroscience expert testimony. Again, Rule 702A is a relevance, or what the court called fit issue. In an article that I'm working on with John Monahan now, we distinguish between logical fit and what we'll call empirical fit. Logical fit is the classic kind of relevance or fit analysis that courts do. Does the neuroscience evidence relate to a fact that's put into dispute by the substantive law? It came up in Adrian's just last example. Those of you who are disinclined to hold Mr. Off responsible pointed to lack of volitional control. Of course, the federal standard is the old Naughton standard, where you can't distinguish right from wrong, but under the old American Law Institute test, lack of volitional control was legally relevant. And so if you come forward and you say, well, I lack volitional control, under the ALI test, that would be legally relevant, logically so. Under the Naughton test, it is not. The alternative type of fit, which is special to scientific expert testimony, is does the neuroscience generalize to the population at issue in the legal dispute? This is what social scientists call external validity problem or generalizability problem. Classic is this area now. There's a lot of research on implicit bias in neuroscience. There's behavioral science on the possibility that race is a factor in capital sentencing. And the question there would be, if you have research done in Georgia, the David Baldus research in Georgia, is it generalizable to a challenge in North Carolina? Can you generalize from one data set to another data set? That's a relevant fit issue. 702B, the testimony is based on sufficient facts or data. These are really the Daubert factors, testability, and it has been tested adequately. There's 1 or 2 courts that have said that if it's testable, that's all you have to do. But the Supreme Court in Daubert specifically said, in fact, they expressly said, not only that it be testable, but that it has been adequately tested. Error rates, we talked about those error bars. Error comes in lots of different ways in science. And when you look at how courts are dealing with the Daubert trilogy in 702, error rates is probably the factor that is the most difficult for courts to implement in a consistent fashion. Peer review and publication, the court said this is not the sine qua non of admissibility, but the ordinary practice of science is that it's given to a journal that is then peer reviewed. Peer review in this context, and I owe this insight to Michael Sachs, peer review means not only the peer review that reviewers for Science or Nature or Cell or other journals might do, but it's also peer review after it's been published. What is the reaction of the community more generally, which of course is also associated with general acceptance, or what the court sometimes refers to as widespread acceptance, which is the Frye test. And I also add a test that came up in Kumho Tire. The court said that a factor that's important is whether the expert is using the courtroom the same level of intellectual rigor that he or she would use in his or her field. That's a fine standard as long as the field is a good field. It doesn't do you much good. It's kind of a Frye-like standard. If you are, tea leaf reading might be extremely acceptable, and you can use exactly the same amount of rigor, but it doesn't do you much good. And there are, from bite marks to handwriting identification to other areas, there are certain areas that simply asking people in the field whether you're using the same amount of intellectual rigor doesn't get you very far. The other point that I think is worth keeping in mind is that a lot of scientific fields have no market other than the law. In the forensic sciences, that's certainly true, and that includes potentially forensic psychiatry that might be using some of the neuroscience, that their market is the law. So you can't really ask the question, unless you broaden your analysis, are you using the same amount of rigor? 702C, product of reliable principles and methods. I'm happy to make my PowerPoints available to anybody who's interested. Now you have the question of, what we're going to come back to, general causation, the general relationship between the, say, a substance and an illness. There are a number of factors that have now been suggested. The Federal Judicial Center's Manual on Scientific Evidence talks about this in one of their chapters, the Bradford Hill Guidelines, ways to assess causation in research. And then, of course, you have specific causation, and we'll come back to some of these issues, and that's differential etiology. Interestingly, differential etiology is a legal term, not a scientific term. I had our librarians search for the notion of differential etiology in the scientific literature, and you can't find it. It's all over the legal literature, and so nobody's really dealt with this idea of differential etiology, which most of you, I think, are familiar with, but basically it's ruling in a putative cause and then ruling out all other causes for whatever you're observing. 702D is, have you applied it reasonably to the facts of the case? Interesting problem of translational science. If you ask scientists, what do you mean by the statement to a reasonable degree of scientific, medical, forensic, psychiatric certainty, most scientists will say, I don't really know what that means, but my lawyer told me to say it. And if you ask most judges, what does it mean? Most of them say, I don't know, the scientists say it, and they must know what it means. Of course, the psychiatrists might have one understanding of what it means to commit somebody. The lawyers might have a completely different understanding of what it means to commit somebody in terms of how you evaluate that. Testifying to group statistics versus testifying to the particulars of this case. One interesting thing on the translational side that, as I'm working on this piece that is in your materials that I'm working on with John, is most judges follow the field. So DNA testing experts testify to random match probabilities. And most other forensic identification scientists testify to a match. And it's rather ironic that the best science available is giving you population frequencies, and the worst forensic science is giving you this matches to the exclusion of all bullets, cartridge cases, fingers in the world. I'm being given the hook, so let me get through just the general things. So the question of Rule 403, do the pretty pictures negatively affect jurors? There are different views on this. Early research suggested that it might have an overwhelming influence. Later research suggests that that's not the case. And I'm not going to do Frye. My apologies to Goodwin. But California is moving away from Frye toward Daubert. So the nature of science, the G to I problem, back in '99, I wrote a book called Legal Alchemy, where I described this problem. While science attempts to discover the universals, hiding among the particulars, trial courts attempt to discover the particulars, hiding among the universals. So scientists use group data. We're interested in individual cases. We call this the G to I problem. You get these, John Monahan, Larry Walker refer to as these social frameworks. You have a framework, and the question is, is this case an instance of that general framework? And so that's the nature of applied science. The basic, so eyewitness identification, most research on eyewitness identification looks at whether, say, cross-racial identification or gun focus is going to interfere with eyewitness accuracy, but eyewitness researchers do not say anything about the accuracy of a particular witness ordinarily within their field. So there's general research, but they're not applying it to the specific case. The current judicial practice is that there's no general theory regarding when to allow experts to testify. Most courts do not allow eyewitness researchers to testify about the accuracy of a particular witness, except Texas. Texas and a couple of other jurisdictions require it, actually, which is interesting. Medical causation, they not only allow statements about individual cases, they require it. If you cannot put on an expert who's going to testify about specific causation in a medical causation case, you lose on summary judgment. So you have these courts going in different directions about when you allow experts to reach the individual case, and they don't have any general theory about that, and there are other examples. Basically, as I said, courts generally follow the lead of the practitioners in the field. I was curious to see whether there would be an effect after Daubert. Daubert is supposed to increase the sophistication of the judiciary. So did this little study. I looked at the number of cases before Daubert, citing general causation versus specific causation. Before Daubert, it was 29. After Daubert, it was 797. Differential etiology, nobody mentioned differential etiology prior to 93, and 116 have mentioned it after. Of these cases, a lot of these are actually not scientific cases, about half of them are, and about half of those cases were done by Jack Weinstein. So Jack Weinstein is the guy right in that box there. Those of you who know Jack won't be surprised about that. So how do you determine this? I'll finish up with this. John and I, as we say in our paper, try to come up with criteria and suggestions, best practices for defining when you allow experts to move from the general to the individual. And they are sort of classic factors, but we're going through how they work in this context. Qualifications of the expert, the relevance or fit, the helpfulness or need. One of the theories is that in medical causation, you need expert testimony on the individual, because if you simply gave toxicology and epidemiology to the jury, they wouldn't know what to do with it. Eyewitness identification, you can give them the general, and they know what to do with it. You don't need the individual inference handed to them. And Rule 403, obvious, comes in, conclusions, discussion, and I'll leave it to you to ask questions. Thank you.